Welcome to the impact of California AB5 on franchisors. This is a presentation of Great Plant Moody's Franchise and Distribution and Labor and Employment Practice Groups. My name is Carl Zwissler. With me today are presenters Michael Gray, Neil Goldsmith, and Erica Tokar. And we'll have pictures of them in just a second. We have intentionally assembled a panel with a diverse background and different perspectives on the problems posed by AB5. Mike Gray is an experienced and highly regarded franchise litigator, author, and speaker. He's represented franchisors in a full range of disputes throughout the country. Mike has had considerable experience litigating vicarious liability, joint employer, and independent contractor claims in California. Neil Goldstein is an employment lawyer who represents franchisors and other employers in virtually all kinds of labor and employment law disputes throughout the country. He works closely with GPM's franchise and distribution lawyers to advise franchisors about employment law issues. It's Neil Goldsmith, not Goldstein. Excuse me, Neil. Erica Tokar's practice focuses on U.S. and international franchise transactions. She regularly helps franchisors draft and revise their franchise agreements, FDDs, and operations manuals to mitigate joint employer vicarious liability and employer liability claims. I'm Carl Zwissler. I offer the perspective of 40 years of experience advising franchisors about all aspects of their U.S. and international franchising programs. I began my career as IFA's Chief Staff Counsel, and later I served as its General Counsel. What have others written about AB5? Well, that's probably why you're joining us today. You've probably seen the headlines: dramatic change to the franchise-franchisee relationship, a fatal threat to franchising. The new California law imperils the franchise model. AB5 would effectively turn franchising into a corporate model where the independent owners and their employees are effectively absorbed into a single company. Or AB5 impacts franchisors in a way that remains unclear. Which is the proper perspective? I think ours is more likely to follow the last statement than the earlier ones, but let's get into the details. The goals of our program are straightforward. We're going to tell you what AB5 requires and what it plainly does not require. We'll explain how AB5's ABC test has been applied to franchising in the other states that have already adopted the ABC test. We'll explain the implications of being subject to AB5 under California's labor, work order, and unemployment insurance laws. And we'll explain some steps franchisors might take to mitigate the potential effects of AB5 on their franchising programs. Before we get into the details, let me give you a quick overview. This program is scheduled to last 1 hour. If you can't stay for the entire hour, or if you would like to see a copy of this program and listen to a recording of it, it will be posted on our firm's website, www.gpmlaw.com, and you'll find it under the events page. Finally, if you have any questions during this program, please write them on the right side of your screen. We will review them and try to get to them, time permitting, during the program. If not, we will get back to you after the program. So, what does AB5 do? It sets a standard under 3 California employment laws for determining whether a worker is an employee or an independent contractor. It adopts the ABC test articulated by the California Supreme Court in the Dynamex case that was decided in April of last year. What is the ABC test? Well, in essence, it boils down to this: everyone who provides labor or services to a hiring entity is an employee, unless each prong of the ABC test is met. Let's look at the ABC test. The A portion, it states that the person is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. B the person performs work that is outside the usual course of the hiring entity's business. And C, the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So what's the problem with the ABC test? Well, if the law applies, most franchisors can usually pass prong A and prong C, but they may be challenged to overcome B. Again, B states the person performs work that is outside the usual course of a hiring entity's business. Now, franchisors with company-owned outlets or which advertise that their company provides certain services may be challenged to escape B. But given AB5's focus on the gig economy targets such as Uber and Lyft, we should expect advocacy of a broad interpretation of the concept, usual course of the hiring entity's business. Does AB5 apply to most franchise relationships? To answer that question, we focus on Section 2 and the general context in which AB5 was presented. First of all, the introduction states that the law applies to workers. Then the Legislative Council's digest of the law says that it applies to individuals. Section 2 states that it applies to persons. So, which is it? And can a person be a corporation? Well, because the law is designed to codify the Dynamics case, let's look at the situation that arose in the Dynamics case and see if that gives us some insights. I think it does. Dynamics terminated the employment relationship with drivers who made deliveries and recharacterized them as independent contractors. The plaintiff in this case was a driver who was paid by Dynamics for deliveries he made to customers designated by Dynamics. The plaintiff had no contract with customers to whom he made deliveries. So, who's intended to be protected by this? We conclude that AB5 is not intended to regulate franchise relationships unless the franchisees are workers who are paid by the franchisor for services provided by franchisees to the franchisor. Neil, how does AB5 potentially apply to the franchisor-franchise relationship?
Well, it's an interesting question, Carl, and I think that's a big question that everyone who's here on this webinar wants to know the answer to. If you look at the headlines that Carl pointed out at the beginning of this webinar, death knell for franchising, turning the franchising model on its head, so on and so forth, it would have you to believe that there'd be a huge impact on the franchisee-franchisor relationship. So our conclusion is that a franchisee is unlikely to be deemed an employee of a franchisor. And that's, at its very basic level, employees are individuals, not business entities. It'd be very difficult to deem a business entity, a franchisee, as an employee. There might be some ways which we'll talk about in a moment, but in general, an employee is a person, is an individual, a worker. If a franchisee fails the AB5, the ABC test, then its independent contractors or purported independent contractors would be deemed employees of the franchisee. So I really view this law as having much more of an impact on franchisees than potentially franchisors because we're concerned about the way that businesses classify their employees as either employees or independent contractors. Now, we'll talk about joint employer in further detail later on in this webinar, but I think that's a topic that a lot of people are confusing with this ABC test and the misclassification issue. The question that I have in my mind is, if under this new law, the independent contractors of a franchisee are to be deemed employees, are those employees then also employees of the franchisor? I think that's the big question here and a potential risk, but I think that's going to be settled based on joint employer analysis and not necessarily changed by AB5. A potential problem that we do have in this context is for franchisees that do not have employees of their own. Single franchisee or one-person shop, that's not your typical brick and mortar. You think of a retail store, for example, a franchisee that the franchisee owns and controls it and has their own employees. If you don't have that model, if it's really just the franchisee on their own working for themselves, I think there is some risk here that AB5 could come into play in this instance, because it could be applied to determine that that franchise owner, that franchisee, is actually an employee of the franchisor. Now, some people seem to think that they can get around this by simply making that franchisee not be a sole proprietorship or a person and an individual, that they are set up as a business entity, an LLC, a corporation, what have you. I think that's helpful in terms of trying to make it seem like that person is not really an employee of the franchisor. However, that's really not going to be outcome determinative. If you do have a single person, even if they are set up as an LLC or a business entity, if it's just them and there's sufficient control that the franchisor is exerting over that franchisee, I think you do have a risk under AB5 that that franchisee could be deemed an employee of the franchisor.
So what happens if franchisees are classified as employees under the ABC test now?
So that's a good question, and something that we should all take a step back and understand what it means to be an employee versus an independent contractor. Why do we care? Why has this been such a big deal? Why have Uber and Lyft been fighting this legislation in the way that they have? What's the difference? So at a basic level, if you fail the AB5 test, the workers that you have that you thought are independent contractors are going to be deemed employees. What that means is going to vary based on the claims that might be asserted against you and the context in which those claims might arise. So there's a few different ways in which claims could be brought against an entity involving misclassification. The most common claims are typically wage claims, where an employee an employee or an agency is essentially arguing, well, I'm an employee, I'm not an independent contractor, therefore I'm entitled to overtime pay and other protections of wage statutes, and you, entity, are liable to me for that back pay and overtime pay and other damages and penalties. There's a few different ways that those claims can actually come up. One is an unprompted investigation by a government agency, such as the Labor Commissioner in California. They have a broad power to essentially investigate any potential violations of the wage orders and labor code. They can do that by examining documents, records, statements, wage records of just about any employer. They can literally come to your place of business, knock on your door, ask to see all your records, and if they're not in order or if they don't think your employees are classified properly, they can issue penalties. You can also have an individual who brings their own claim to a government agency that prompts a specific investigation regarding that particular worker. And then, of course, there are claims that can be brought in court, whether as an individual lawsuit, a class action, or a PAGA action. And I want to highlight PAGA for those of you unfamiliar. In California, they have the Private Attorney General Act, which essentially acts as another avenue to bring sort of a class action type lawsuit. But there's two important distinctions that I want to raise regarding PAGA claims. One, there's no class certification requirement for PAGA claims. That's something that often stops class actions from proceeding. The class does not get certified. There's no such requirement in a PAGA action. And also, PAGA claims are not subject to arbitration. So even if you have a mandatory arbitration clause with employees or with franchisee, they still could be able to bring PAGA claims in court. Those cannot be arbitrated in a mandatory fashion. So let's keep in mind, though, what AB5 applies to. What the AB5 test applies to are essentially three different laws: the California Labor Code, California Workers' Compensation laws, and the California Unemployment Insurance Code. And what that means is an independent contractor could be deemed an employee for purposes of these laws, meaning that if you didn't pay the minimum wage, you'd be entitled to pay the minimum wage. If you didn't provide them proper meal and rest breaks, paid sick days, so on and so forth. There's a number of very strict requirements that California has in regards to wage and hour laws that all of a sudden, if you weren't satisfying those with your independent contractors, you can incur liability now that they've been deemed employees. Also, workers' compensation laws. Typically, you don't provide workers' compensation for independent contractors. So let's say someone gets hurt on the job and they were misclassified as an independent contractor and they were really an employee, you're going to be on the hook for that as their employer. Same with unemployment insurance. This is often where misclassification issues come up, where independent contractors are let go, terminated, and they file a claim with the unemployment insurance agency, and it's determined by that agency that they're actually employees and not independent contractors. So that's what AB5, those three laws are what AB5 applies to specifically. I do want to mention other potential liability that is out there in regards to misclassification that's not specifically covered by AB5, but could very well be used as evidence of misclassification in other settings. Whether or not someone is an employee really depends on the specific law and the specific jurisdiction where that employee is. So, for example, some of the payroll tax laws are not covered under the Unemployment Insurance Code. You can bet, though, if a worker is found to be misclassified and deemed an employee and not an independent contractor under the Unemployment Insurance Code and AB5, I think there's a strong likelihood that that same evidence is going to be used to apply in other payroll tax contexts. Same with ERISA. You might have a claim that under ERISA that a certain employee or a certain worker should have been entitled to employee benefits because they were misclassified as an independent contractor. The Fair Housing and Employment Act in California, Title VII, anti-discrimination laws. You could have an argument there that the worker should be deemed to have protection of those laws because they are improperly classified. And then, of course, there's general tort claims. There's vicarious liability, respondeat superior principle in employment law that an employee is essentially the agent of their employer, and therefore the employer is responsible for any actions that the employee undertakes in furtherance of their employment. So if that employee is deemed to be found, or if that independent contractor is deemed to be found an employee in the AB5 context, I think that evidence could be used to support a misclassification finding in another context.
Thank you, Neil. Erica Tokar, which of AB5's exemptions and exclusions may apply to some franchise organizations?
That's a great question, Carl. And the answer is maybe some, maybe none. The text of AB5 includes a variety of exemptions. Actually, most of the text of the law is exemptions. And the effect of qualifying for an exemption under AB5 is that the ABC test does not apply. It does not mean that the worker is automatically an independent contractor. It just means that we look at the more elaborate 11-part test that that predated dynamics. None of the exemptions expressly applies to franchising, unfortunately. The IFA and other advocates zealously pushed for an exemption that specifically would have been geared toward franchises, but it was not incorporated in the final bill. The exemption that was proposed, the way that it was structured, it didn't exempt all franchises, but rather stated that a franchisee would not be deemed a franchisor's employee unless the franchisor exercised a degree of control that is not customarily exercised to protect the franchisor's marks and trade dress, including quality control, et cetera. Seemed reasonable to me. One explanation provided by legislators or others during negotiations for why that exemption was not adopted is just that franchising is too broad of a business arrangement. There was some concern that that type of exemption, they didn't want to exempt all franchisors. There was a concern that misclassification issues could potentially be present for some types of franchises. And so in 2019, it wasn't successful, the efforts to implement that exemption. I recently spoke with some of our friends over at the IFA who are on the ground in Sacramento, and they are actively working with folks to engage with the organized labor community and others to see what form of exemption they might be able to put together, though, for the 2020 session. We're hopeful that this might be part of what I've heard termed a cleanup bill that will clarify many of the issues that we're discussing today. So there's definitely a continued and renewed effort to get an exemption in place. However, looking to the bill in its current form, there is an exemption that arguably applies to the franchising business model. We would sort of be putting a square peg in a round hole to make that argument. There is not an express carve-out. Some of the exemptions that arguably could apply have to do with specific named occupations, so veterinarians, accountants, and others. One exemption that some folks have speculated could potentially apply in particular is the business-to-business exemption. My understanding is that at some point, advocates considered that there could be a B2B exemption that was crafted to apply to franchisors, but that did not pan out. So the existing B2B exemption was not drafted with the intention that it would apply to franchisors. What that exemption in its current form states is that the ABC test does not apply to a bona fide business-to-business contracting relationship. Which sort of sounds like franchising until you read on. Basically, it contemplates a relationship between a business entity that provides services to some other business. It could probably be read in different ways. The way I read it at the outset is that we're talking about it would have to be a franchisee performing services for a franchisor, which again is kind of why it's a square peg in a round hole. I'm not sure that really works. And to go on, there are 12 additional criteria that would have to be met. Some of them could easily be met by franchises, such as the requirement that a business provider maintains a business location that is separate from the business or work location of the contracting business. That seems reasonable. That's how most franchises are structured. But others really don't seem to make sense in the context of franchising at all. For example, there's one of the prongs is that the franchisee must be customarily engaged in an independent business or independently established business of the same nature as that involved in the work performed for the contracting entity. So to me, that seems to require that the franchisee would have to have a franchise business and then some other business that does the same thing as the franchise business. It all seems like a bit of a stretch to me. One thing that is also worth noting, though, about the B2B exemption is looking at it for your specific type of business, you think that it might qualify. And that you might be able to avail yourself of that exemption. It's only available to entities. So, a theme throughout our discussion today is, these individually, owner-operated businesses versus franchisees that are established as entities. And so the B2B exemption is just one more reason why encouraging franchisees to incorporate or to operate as entities might be a good thing, because at least you have not foreclosed the B2B exemption. In theory, there are some other exemptions that could apply to franchise relationships. For instance, there's an exemption for individuals that provide licensed healthcare services. Licensed healthcare services providers are exemptions or have an exemption. So I think the way that those specific occupation type exemptions could apply is if you are a licensed healthcare provider, there's some franchising dimension to your relationship with a third party. More like an accidental franchise type relationship, frankly, where there's a trademark license and a fee payment involved, so arguably franchise laws are implicated. But the ABC test won't apply because that industry-specific exemption is in place. Unfortunately, I don't think the B2B exemption, any of these occupation-specific exemptions or others, are really likely to assist traditional franchises very much.
Thank you, Erica. Mike Gray. What effect has the ABC test had on franchising in the other states that have adopted it?
Well, Carl, I think it's maybe news to some people, at least recently, that there are a number of other states that have and have had, in some instances for a long time, adopted the ABC test in terms of determining whether a worker is an independent contractor or an employee. Some of the states are listed on the slide there. There are some modifications to a few of these statutes, but essentially the same the same test in terms of the ABC prongs, as they're referred to. Some of the cases that are decided there are franchise cases, mostly in Massachusetts and Connecticut. The thing about these cases is they were not final, not all of them were final adjudications of that issue. In the first case, the coverall case, that was actually an unemployment insurance action by the commissioner of the Unemployment Insurance Division. And in that context, they found that the franchisees in that case were employees for purposes of unemployment insurance because the franchisor was not able to satisfy the second prong of the test. In the second coverall case in Massachusetts in 2010, that was a partial summary judgment. And again, they failed the second prong, and the court found that by summary judgment, partial, that they were misclassified as independent contractors. The DiBianti case was a class certification question, and the interesting defense there argued was it's a three-tier system, that the franchisor, an intermediate master franchisor, and then the franchisees. And they argued in that case, because the master franchisor had no direct contract with the franchisee, they could not be held liable under the ABC test. They certified that question to the Massachusetts Supreme Court, and that is the decision that's listed there. And they said that a lack of a contract between the parties does not preclude the application of the ABC test in this instance. And then the last case, the Mujo case, was also a class certification case, and it also found in the context of the class 23 elements, under the predominance elements, they went through the ABC test, and again said there's predominance. There are issues. They made a sufficient showing, the franchisee did in that case, to move forward with class certification, and they did certify the class. Now, how these cases actually resolved themselves, I don't know. My guess is they were probably resolved shortly thereafter. But my point for these cases is to show two things. One, there are other franchise cases in these other states that have applied the ABC test. As far as I know, these franchisors are still in business. The ceiling has not fallen down on them. But the last thing to point out is each of the concepts, the franchise concepts here, did involve the sort of single franchisee with either a single account or a single van, so to speak, and a direct communication between the franchisor and the ultimate customer. And the franchisors in these cases collect the money from the customer and then pay the franchisee after deducting the franchise fees. So it's not a traditional brick and mortar type of franchise concept. Their structure in the way that they operate their business makes it more difficult for them to get through the ABC test, especially the second prong.
Thank you, Mike. Neil Goldsmith, how does AB5 affect a franchisor's risk of becoming a joint employer?
Well, one thing to keep in mind, if you come away with nothing else from this webinar, is that AB5 is not about joint employer liability. It's about misclassification. Those are two similar concepts, but different concepts. There's nothing in AB5 that mentions joint employers. If you look at the final amendment to AB5, the purpose was amended to specifically state that the purpose is to protect workers exploited by being misclassified as independent contractors. Going further, the chief sponsor of the bill has even stated in a letter that AB5 is not intended to replace, alter, or change joint employer liability between two businesses. The Salazar versus McDonald's case that came out just this week confirms that, and Mike's going to talk about that in further detail later on. So what is the relationship between joint employer and misclassification? So when you're looking at when you have a misclassification case, the key question is your purported independent contractor really an employee? When you're looking at a joint employer case, the question is, are you, business entity, franchisor, are you the purported employer of this employee? Where these concepts overlap is the concept of control. The concept of control is present in both a misclassification analysis and a joint employer analysis, but it arises in different contexts. In a misclassification concept, if you look at prong A of the ABC test, it's that a person is free from the control and the direction of the hiring entity in connection with the performance of the work, both under contract and in fact. For a joint employer analysis, you're essentially looking at the same thing. You're just replacing the word hiring entity with alleged joint employer or franchisor, if you will. The question is a matter of control. Who has control over this individual worker? At a misclassification case, you're determining whether or not the hiring entity has sufficient control over the individual to deem them an employee of the hiring entity, whereas in a joint employer context, you're looking at the question of whether or not a separate entity, like a franchisor, has sufficient control over the employee to deem them also an employer of the employee. So in a misclassification case, the identity of the hiring or controlling entity is not disputed. The question is clearly set to, you are the entity that controls or has a relationship with this individual. Is that individual an employee of yours or not? In joint employer cases, the identity of the hiring or controlling entity is exactly what is being litigated, exactly what is in dispute. You essentially have two entities kind of pointing fingers back at one another saying, well, no, you have control over this employee. And they say, well, no, you have it. Or maybe we both have control over this employee. That's really what's in dispute in joint employer. Mike, do you want to tell us about some of the key cases here?
Sure. So I thought it would be helpful to just touch on a couple of the important cases in California that kind of flesh out the principles that we've talked about. The first is the Curry case, and it came out in 2008. It's a Court of Appeals case. And I'm going to talk about both California state court cases and Ninth Circuit cases because it's important to distinguish between the two. The Curry case was not a franchise case per se. It was a lessor lessee case. It involved a Shell gas station, and the manager of the Shell gas station claimed that she was employed by not only her boss who owned the gas station, but by the Shell company who sold the gas and leased the property to the gas station owner. And in this case, the court said the ABC test does not apply to the issue of whether Shell, who sold the real gas and leased the real estate, was also the joint employer. And they said the reasons why it doesn't apply is because of the stated policy reasons behind ABC, which Neil just referenced. If it's intended to protect workers and allow them to get workers' compensation, unemployment, minimum wage, meals, breaks, et cetera. And so these employees who are misclassified are not a burden on society. In this case, the manager was clearly an employee of the gas station owner. And so there was no need to go beyond that. And the court said that the ABC test just doesn't apply in the joint employer context. Now, what's caused some confusion about this case is the court went on to say, well, even though we don't think it applies, even if it's applied, it doesn't work. Shell, the employee has not met the burden, or stated conversely, Shell did meet the ABC test. You can go over the decision. It's a little confusing, but they essentially said that for prong A, that Shell corporate did not have control over the manager's wages, hours, working conditions. Under B, this is where the case got a little criticism. They said Shell, the gas company, didn't operate gas stations. It leased real estate and sold fuel. And the gas station owner was in the business of operating gas stations. And that's an interesting finding for franchisors to separate those two types of activities out. And under prong C, the court said, look, we already said there's no control under A. Under B, they're different businesses, so we're going to find that that the manager was in an independent business operation. They kind of did a blend there. So that's the California Court of Appeals case. The next case is Vasquez versus Jan Pro, and this is in the Ninth Circuit, so the federal system out of California. This is a misclassification case, and it did apply the Dynamex case and the ABC test in Dynamex. But the interesting thing is the franchisor in this case argued that there should be a gloss applied to the analysis based on the Patterson-Domino's case. And the court rejected that flatly and said, there is no Patterson gloss here because Patterson was not a misclassification case. It was a pure vicarious liability case, and because of that, we're not going to apply it here. Now, the court remanded the decision after it made the determination that the ABC test applied. Significantly, it gave a lot of coaching back to the district court about how to apply the ABC test to the specific facts in the Vasquez case. Procedurally interesting, later the court withdrew the opinion, then reissued the opinion, but in so doing, took the retroactivity issue out and certified that to the California Supreme Court just last month. So that's the federal court in California on a misclassification case. The last case I want to talk about was the case that actually came out yesterday. And this is Salazar versus McDonald's, again, Ninth Circuit, but a joint employer case, distinguished from the Vasquez case, which was misclassification. Here, there was no mistake that the McDonald's franchisee was the employer, and the employees of the McDonald's franchisee brought some wage and hour claims under California law. The only issue in front of the court is McDonald's, the franchisor, a joint employer for liability under those claims? Dynamex was argued to apply. The franchisees said you have to apply the ABC test to determine whether McDonald's should be liable, and the court flatly refused and said Dynamex does not apply to joint employer issue because Dynamex is a misclassification case. So here we have a clear line of demarcation as to the applicability of Dynamex, and we would argue thus the AB5 because it has no application in joint employer. Now, also significant in Salazar is they cited to Curry, the case I discussed earlier, and the Patterson case for the applicable joint employer standards. And again, if you recall the Patterson case, it's all about control. It's all about exerting control over the franchisee and its employees. So in this case, it provided some clarity and some bright light to the confusion that was created by whether AB5 and Dynamex applies to joint employer issues, and it clearly does not.
Mike, we have one question on a topic that you've just covered. I actually have two, but I'm going to ask you one. Of the states that you've identified as having the ABC test, does that apply to all types of labor laws, wage and hour, unemployment, or workers' comp? Do you know if it's isolated?
You know, Carl, there's almost 20 states that are listed there. I couldn't give you a definitive answer on that. I can assume, to the extent that one of the cases was brought by the unemployment insurance compensation in Massachusetts, that would apply. I think it's fair to assume, and maybe Neil can comment on this, that wage and hour would certainly be a big part of that, as well as workers' comp and unemployment. Beyond that, I'm not sure I'd be willing to venture a guess. Neil?
Yeah, and I think that's probably right. Certainly wage and hour laws, I think that's the main driver behind a lot of these misclassification cases. But that is an important thing to keep in mind when you are in a state that has an ABC test or a similar type test or a law similar to AB5. You want to look very closely as to what exactly that AB5 or that ABC test, which laws those apply to, right? Is it You know, I was a bit surprised when I was looking at AB 5 that it didn't include the definition of employee under the Fair Employment and Housing Act in California, and I think some people out there are automatically assuming that it does apply to that, but it doesn't, because that's separate. That's a different part that's not in the labor code. So you need to be very clear and very careful when you're looking at these laws and see to which other wage and hour laws does this analysis actually apply.
Thank you, Neil. Erica Tokar, AB 5 is said to apply retroactively. What's the significance of that, and what are the applicable statutes of limitations that franchisors would need to be concerned about?
Interestingly, Carl, this retroactivity piece wasn't really the focus of advocacy efforts before, when the legislation was being debated, presumably because securing an exemption that specifically addressed franchising would have been a much more effective approach. But now that the bill has passed, it's certainly become a focal point. So typically, sort of as a matter of statutory interpretation, the assumption is that new legislation applies prospectively if the statute is silent. Here, however, AB 5 is not silent. It includes a couple of express statements on retroactivity that apply to different sections of the law and the different applicable California employment statutes. Our challenge may be making sense of what those statements mean. So regarding retroactivity, AB states the following. First, it states that the ABC test does not constitute a change in, but is declaratory of, existing law with regard to wage orders of the Industrial Welfare Commission and violations of the Labor Code relating to wage orders. So this does seem to indicate pretty expressly that the bill is intended to be retroactive in the wage and hour context. Another section of AB 5 also states that the exemptions that I talked about earlier apply retroactively to the maximum extent of the law if they would operate to relieve an employer from liability. So there we also have an express statement with regard to those exemptions. Another express statement is that the change in the definition of employee under the section of the Labor Code that deals with workers' compensation, which is 3351, will not be retroactive. And then the third category, as Neil mentioned earlier, there are three different statutes that are implicated here. Section 621 of the Unemployment Insurance Code, there's no statement on retroactivity for that piece. So in general, the issue of retroactivity depends on what part of AB 5 you're looking at, and there are some open issues. At this point, for portions of the statute that might be construed to be retroactive, impact litigators are currently contemplating the right approach to contesting the retroactivity in court, but at least part of that issue is essentially already being litigated. As Mike mentioned earlier, recall that AB 5 expressly states that it's intended to be the codification of the dynamics decision and the ABC test that's described therein. And that issue, the issue of retroactivity, is currently pending with the California Supreme Court in Vasquez on that. So the outcome in Vasquez will essentially answer the question of whether AB 5 and the ABC test can permissively be applied retroactively in the wage and hour context. With regard to other areas, where the statute could be construed to be retroactive, there are certainly challenges that could be levied. Constitutionality challenges based on the impairment of the existing contracts. We've seen that before in other contexts. For sections of the Labor Code that might have criminal ramifications, there could be due process arguments, ex post facto arguments. So we will see whether the issue of retroactivity is addressed in the 2020 cleanup bill, and then if it's not, I expect that we will see some impact litigation going forward. For the sections that are, parts of the statute are read to be retroactive, the applicable statutes of limitation range from 8 to 3 years, and 8 years is a long time, so this could definitely be a big deal.
Thank you, Erica. Now let's move on to the part of the program where we try to answer the question, or at least give some suggestions as to what a franchisor might be able to do to mitigate the potential adverse effects of AB 5 if the franchisor thinks that it might apply. Mike, what do you suggest we start with?
All right, well, I think it's important to start this conversation with the caveat there is no silver bullet, and it really is going to depend on the nature of the franchise system structure. The cases that we've looked at have indicated that plays a significant role in whether franchisors are able to satisfy the ABC test, and you see some trends in the types of franchisors that have been challenged with this, and they generally involve systems that have, the single franchisee, the contract, the contract with the customers with the franchisor, and they do the accounts receivable and pay the franchisee after the work is done. Those tend to lend themselves to really difficult challenges in meeting the ABC test. So no structure, the structure is very important. The kind of questions you want to ask is who generates and controls the customers? How does the money flow? And how much control does the franchisor have over the franchisee's day-to-day operations? And as Neil mentioned, you have to understand the differentiation between misclassification and joint employer risk. For the first type of structures, what I call the individual franchisee model, the one person, one van, one account, no employees, not incorporated, and the franchisor collects money and pays the franchisee back. As I said, that makes it very difficult to prove ABC. Here's some things that they might consider. Make the franchisees incorporate and operate as an entity. You heard Neil say that that's not a magic bullet, and I'm not suggesting that it is, but it is one element that can be pointed to as some differentiation and lack of control, especially in California. And if you have a contractual agreement that the entity must comply with California wage laws, that then puts the burden on that individual entity to comply. Require the franchisees to generate their own percentage of their own accounts. In several of those systems, the franchisor takes on the responsibility of locating work accounts and customers for the franchisee. Potentially shifting some of that responsibility to the franchisees on their own would indicate a level of independence that could be a point of differentiation. Have franchisees collect revenue and report to the franchisor. There are several models, and most models, it goes that way, that the franchisees contract with the customers, collect the revenue, and then do a fee report to the franchisor. They could switch their system to that type of model. Minimize operation controls to brand standards. Again, scrutiny over the operating manuals, the day-to-day, the franchise agreement, et cetera, and make sure that the controls that they exert are limited to protecting trademark and brand standards. Include mandatory individual arbitration clauses in the franchise agreements. I know that has its challenges in California. The California arbitration law could be a seminar all by itself, but it is one line of defense that would work other than with PAGA claims, but some franchisors are willing to let those sit in court while you duke it out in arbitration, because the outcome of the arbitration generally then resolves the PAGA claims. The other is to watch for struggling franchisees and take action. These claims come from franchisees who are working long hours and potentially not even making minimum wage, struggling financially. Those are the people that you want to pay attention to, either prop up, help usher them out of the system, get them bigger, whatever, but kind of minimize risk by managing franchisees that are struggling. Another is to consolidate accounts, to create larger franchisees who become the hiring entity that employs workers. I know some of these models are based on single individuals, but helping them to grow and have their own employees and become their own hiring entities would minimize the risk in California. Some drafting issues, the franchise agreement pre-sale acknowledgments could include representations regarding the nature of the relationship, who are workers, who's the hiring entity, some language that could be protective in terms of claims later that the franchisee acknowledged that it was not an employee or a worker and that they are the hiring entity, et cetera. The franchisor can change its especially outward-facing messaging regarding the nature of the franchisor's business versus the franchisee's business. So you recall from the Curry case, that's one of the elements that the court looked at and said, look, the Shell sells gas and leases real estate. The owner of the gas station runs gas stations. Well, if your your website says we operate gas stations all over the country, you know, that's a difficult thing to walk back. So look at your outward messaging and try to differentiate the franchisor's business, which is selling and supporting franchisees. Buyer beware, there are some courts that have not bought that argument. Spin off corporate locations to non-affiliated entities. One of the things courts look at is whether the franchisor operates corporate locations. If they do, it's hard for them to say they're not in the same business as the franchisees. Add auto termination provisions to the franchise agreement if a court or arbitrator rules that there is an employment relationship. I'm not aware of any franchise agreement that has that. It may have its challenges in California under the California Act, but there was a question that came in and said, what happens if the court determines there is an employment relationship? Well, none of the cases that have been reported actually deal with that issue and answer that question. I can only assume that there was a negotiated breakup in the relationship or a change in the relationship in order to resolve the dispute. But the franchise agreements don't then become employment agreements because they're just not drafted for that. Get releases whenever possible, early and often. If you have franchisees in California that are signing agreements, transferring, amending, or are changing programs, get releases in those documents to kind of cut off liability going backwards. And adopt an employment model. I mean, that's kind of a last resort, but it's certainly in California something that you could do if the franchisees are willing. I question whether a lot of franchisees want to be employees, but you could certainly do that in California to minimize risk. Turning to the traditional brick and mortar model, again, I think the risk here is more about joint employment, not misclassification. But some of the things we just went through are things that you could add to that, and here's a few others. Don't allow franchisees to regularly use independent contractors to perform routine job functions. And I know there's some red flags going off saying, well, wait a minute, isn't that exerting control over the franchisee about their employment practices? The answer is yes. It's a balancing test here. If you know that some of the franchisees in your system are using what they call independent contractors, but would not otherwise pass the ABC test, you have to look at whether you want to step into that situation and require that they correctly classify those people. I think probably the way to do that, and I've seen it done, is because if you know they have independent contractors and are not complying with wage and hour laws, you can put them in default under the failure to obey all laws clauses and not treat their purported independent contractors as employees. The other, of course, is always been the answer for the joint employment issue is to control brand standards and trademark protection, what I call the deliverables. The controls should be limited to that primarily, and that's the learning from Patterson and Curry. And I think most franchisors have already gone down that road and scrubbed their documents of unnecessary controls. But again, if you haven't done it yet, this is another opportunity to do that. The deliverables is what I call the customer experience, the customer, what they look and see and feel and what they get. The franchisor is entitled to control those aspects of the deliverables, and beyond that, that's where you get into some trouble. Require franchisees to get unemployment liability insurance with the franchisor endorsement. I know this insurance is very expensive, but it's something to consider, to look at, price out. I don't think having the franchisor as an additional insured under those policies is adequate. I think you have to require the franchisee to get a specific endorsement covering the franchisor. There's been some litigation about that, and that's best practices these days. Mandate that franchisees comply with state labor laws. Many franchise agreements just have a broad base, you have to comply with all laws. I think those should be bolstered to includes specifically labor laws, wage and hour laws, et cetera, especially in California. Bolster indemnification for employment and wage and hour claims. Franchisees always have indemnification clauses, make sure they're broad enough to cover those claims. And as I said earlier, if you know a franchisee is misclassifying, my advice is to take some action, whether that's putting them in default, counseling about their potential risk, or forcing them to correct the situation. But I think doing nothing with knowledge of the problem is not the way to go.
Mike, thank you. That's been a very comprehensive and helpful summary. And I know the application of some of these principles will vary considerably depending upon the individual businesses that are involved. But we present them to you to stimulate some thought, and some of them may be applicable. Well, we've answered all of the questions that we've seen, and we have completed our formal presentation. I would like to thank the speakers, Michael Gray, Neil Goldsmith, Erica Tokar, and I'd also like to give a special thanks to Kim Bradshaw, Chris Field, Chris Emmons, Jessica Heck, and Christina Campbell for helping to make this program possible. Thank you very much. If you have further questions, feel free to call any of us at any time. We have one more question that just came in. Service-based franchisors often negotiate national account work, which is performed by franchisees. Should this continue? Neil, you want to take a stab at it?
I don't know why you wouldn't. I mean, service-based franchisors do national accounts, and should that continue? I'm not sure what the concern is with respect to that. If you're talking about
the payment.
Yeah, okay. If you're talking about the risk of the franchisor controlling the customer contract, I think in a traditional model where the franchisee performs the work and either bills the customer locally or the national account and then submits the report to the franchisor and deducts the fee, I don't think that's a problem. I also don't think that's a pretty normal practice in a lot of different service businesses. So it's usually not a huge percentage of the franchisee's revenue. So I don't see, and a lot of those are voluntary programs. Franchisees don't have to participate in national account programs. They either opt in or opt out. So for those reasons, I'm not terribly concerned about those in the ABC context.
Good point. All right. Well, I think we now have concluded it. Let me tell you that, again, the slides are going to be posted on www.gpmlaw.com under the events section. They should be posted within the next 48 hours. Thank all of you for your time and for your questions. Please contact us if you have any more questions. Have a good afternoon.